Okay, good afternoon, ladies and gentlemen, and welcome again to one of the CLP's student speaker series. Today we're fortunate to have a distinguished former practicing attorney and now professor at University of Maryland. Before I start, I want to apologize and also bring greetings to Sheldon on behalf of Dean Minow, who sends her regards, as well as David Wilkins. Professor Wilkins is around the world these days. He's in Africa and could not be with us, and extends his regrets that he couldn't be here. But we're really fortunate today to have a former colleague, partner who, like me, practiced for a number of years, but is now in the academy and teaching. But by way of background, Sheldon has written a book, The Legal Profession, What is Wrong and How to Fix It. And Sheldon is a distinguished visiting professor of law at the University of Maryland Law School, teaching courses on business crimes and professional responsibility. Prior to that, Sheldon was a partner at DLA Piper, one of our country's largest and most respected international firms. He began his career practicing in the area of organized crime and racketeering in the U.S. Department of Justice. Professor Krantz, as he's now referred to, also served as Dean of the University of San Diego Law School. And prior to that, he served as a professor and director of the Center for Criminal Justice at my alma mater, Boston University. So we're very fortunate today to have Professor Krantz here to talk to us about the profession that we all love and care about, and hope to someday, I suppose, many of you go into. And there'll be an opportunity after his short talk to talk to him specifically about his book, and if you're interested in buying his book, you can do that as well. So I yield the floor to Professor Krantz.
Well, thank you very much. It's a pleasure to be here. I'm going to speak for a few minutes, but I want to leave as much time for questions as I can. And my starting point is that the legal profession is in desperate need of reform, and that many of you, as the next generation of lawyers in this country, have an opportunity to really make the necessary reform happen. Like many lawyers, I was initially drawn into the profession because of the role that our profession has played historically in creating and shaping our nation. I also thought that lawyers had a unique ability, with the training they have, to help those in crisis and to ensure that equal justice and fairness are more than abstract principles, and we were not governed in terms of the clients we took simply by whether or not they had an ability to pay. But I regret, even though I have had the good fortune of having a wonderful career and doing a lot of different things, but I have growing concerns about the legal profession, which really drew me into drafting this book. And I want to share those with you, and I also want to talk about what I think needs to be done. First of all, let's talk about why, in my view, this is a good time to be exploring the area of reform. I better turn on this. All right. The recession that started roughly around 2007 has had a dramatic impact on the profession. And actually, I just noticed a story in today's Wall Street Journal, which said that law firms, the Great Divide, and there's a reference to the fact that two major firms have had sharp declines in revenue. Bingham McCutcheon, which has some Boston roots, and Patton Boggs, which in Washington. The demands for lawyers in private practice are changing. Sophisticated clients have begun to raise questions about what we charge and the kind of services we provide. And they are actually refusing, as many of you may know, to pay the cost of training young associates who are in their first and second year of practice. There is new competition for the legal profession from web-based providers, oftentimes not lawyers, and this is having an impact on middle and small-sized firms. There have been some significant layoffs, not only of associates, but partners in big firms. And I know from personal experience that some of my colleagues have gone on to do other things. And because there's been pressure to cut back on government, there are also declining opportunities there as well. The other thing that I've noticed, and it's important, I think, for you as, again, lawyers who are going to be entering the profession to know that many lawyers hate what they do. It's not surprising that the profession is unsettled. Up to a third of the young lawyers who enter law firms change within 3 years of the time they arrive. And recent surveys have indicated that up to 40% of lawyers who were interviewed recently in a survey said that they would like to leave the field altogether. And let me just give you kind of an illustration, because I interviewed a lot of lawyers during the time I was writing this book, what one of them said to me. She said, "We have to wait for years before we get the kind of challenging work that allows us to grow and advance. And the situation has gotten worse recently because partners want to do more of the work that they used to delegate to associates so they can meet their own billable hour requirements." And an even higher percent of lawyers that I've talked to indicates that they would not recommend that others enter the profession at all. And obviously, this is very disturbing. It's not unusual for people to complain about what they do. It's also, in effect, not unusual for people to want to move into something else. But I think there's something more at play here. Lawyers in growing numbers are questioning the value of the service they provide and to whom they are providing them to. And many are finding limited gratification in simply protecting the interests of the wealthy. My next point. There are more than 1 million lawyers in America, but most people, and there have been an estimate that it may be up to 80%, who have legal problems don't have the means to hire one. And it's ironic at a time when lawyers are feeling something is missing in their lives, that there is such an unprecedented access to justice crisis, and somehow we cannot manage to deal with that problem in spite of the number of lawyers we have. According to one recent survey, over 64 million Americans with civil legal problems do not have access to lawyers. And this does not include the vast number who have some means, but not enough to pay the hourly rates that most lawyers and law firms charge. And our profession has utterly failed to deal with that problem. Next point. The legal profession retains a virtual monopoly in our country over providing advice and counsel on legal matters, and has resisted allowing any others to step in and help. As a result, most people facing problems such as eviction, loss of benefits, loss of child custody, among other legal problems, must navigate the confusing legal system on their own without the help either of a lawyer and without the ability to turn to anyone else for help. And the final general comment I will make, because I am in a law school, is that there are fundamental questions being raised about the role law schools play or fail to play in addressing problems facing the legal profession. As I will point out later on, Harvard is an exception in this regard. But if you take a look at what most law schools focus on, It may be on law reform, but it's rarely on legal profession reform. And the fact that law schools are isolated from the profession is a serious problem, again, which I will talk about in a moment. Now, I'm convinced that the problems I've just described and the attitudes that lawyers often have about what they do and the critical needs that so many people have provide a golden opportunity to transform the profession. And I'm also convinced that this generation is the one that can play a leadership role in doing so and beginning that process now. It's very interesting that at this particular moment in history, it's estimated that about half of the legal profession, about 500,000 lawyers, many of them coming from the baby boomer generation, are retiring, which leaves a kind of an opportunity for those who will replace them to change the nature of the profession we have. As Judge Patricia Wald, who is the retired Chief Judge of the D.C. Circuit, and Esther Lardent, who is the president of a very important organization called the Pro Bono Institute, said in the foreword of my book, make no mistake, change is coming to the profession. It's urgent that it be in the right direction and that it be, in effect, guided toward realization of the aspirations of a noble profession, which is what we should be. Now, I recognize it's easy to define problems, and I spend as much time as I can as a result talking about what are the solutions. And I want to kind of very quickly review these with you before opening up the opportunity for questions. The reforms I talk about fall into three separate categories. The first is the need for us to deal with the access to justice crisis and what that should involve. The second is how to make law firms more responsive to client and public service needs, and frankly, to the professional development of their own lawyers. And the third is how can we involve law schools more directly in legal profession reform? Let me turn to the first, dealing with the access to justice crisis. I make 7 or 8 different recommendations about what the profession needs to do, and let me just touch upon each of them. The first is we really have to aggressively and relentlessly fight for public and private support for legal services programs. Legal services in the last 2 or 3 years has had a declining budget from something in the neighborhood of over $400 million, $420 million, to $348 million. That's just in 2 or 3 fiscal years, at a time where levels of poverty are continuing to increase. Major foundations have not been supporting efforts to provide legal services to the poor. So the profession needs to step up and fight for far more funding. And I can tell you from my perspective as a practicing lawyer who's devoted a lot of time to various courts in dealing with a whole variety of problems, the crisis in access to justice, in my view, is equivalent to the crisis we faced in terms of adequate health care. We have to, as a nation, invest properly to make sure that everybody has equal access to justice. That's point number one. Point number two, we have to shift a lot of lawyers, and particularly this relates to the next generation of lawyers, into public interest work. And in some ways, what's happening in the recession is going to require that be the case anyway. For those of you who've looked at some statistics, we have now reached a point where about only 50% of graduates from law schools are now going to work in private law firms. And that's because of the dramatically changing market. And the issue is, what can be done to promote a movement into the public interest field? And I think there have been some encouraging developments. I noticed recently the Redstone support to Harvard Law School to promote public interest fellowships. It was a substantial gift, but there have to be incentives now to move people into the public interest. And that has to include not only fellowships, but continuing to do far more work to support loan repayment programs, eliminating loan payment requirements, and frankly, I feel strongly enough about it that to the extent there are any royalties that come out of this book, they're going to go to public interest fellowships. So I think we need, as a second point, to aggressively promote that field, and I want to make one other comment with respect to it. A very high percent of lawyers in this country are clustered in urban areas around major cities. We have a vast country, and there are a lot of rural communities, small towns, where there are no lawyers at all. And we have to, I think, really instigate interest in having people become community lawyers in small communities all around the country. And I recognize, as do many others, that people going through law school who look at the salaries of young associates going into the bigger firms wonder how they could survive doing something else. But as I did interviewing of a lot of lawyers who've decided to leave bigger firms, their view is making a substantial amount of money is not enough. There's more rewarding work to do, and it's amazing what one can live on. That is the comment I heard consistently from people I talked to. My next point with respect to access to justice is that law firms, large and small, have to offer greatly reduced fees to reach out to that 80% of the population that cannot afford what big law firms particularly charge. There are some interesting precedents to follow. Bain, which was, as you know, a major consulting firm, ended up creating an affiliated organization called BridgeSpan. And BridgeSpan provided opportunities for Bain associates to move into the sector for a lower salary to provide its services to nonprofits and others who could not afford the rates Bain charged. Why can't law firms do the same thing? Why can we not begin to establish affiliates? And I'm sure we will find a lot of lawyers who would be willing for lesser pay to work in those affiliates and do more rewarding work. I was also involved running an affiliate for DLA Piper called New Perimeter. And that affiliate, which was primarily for pro bono services, gave lawyers the opportunity to work on rule of law projects all over the world. And I cannot tell you the number of young lawyers who decided they wanted to do that instead of practicing law. So there are models, and we have to figure out ways of developing a better fee structure to provide opportunities to serve a major population that's not being served today. Very quickly, some other comments that I made. I'm convinced, even though there are arguments to the contrary, that the legal profession has to have mandatory pro bono. We have aspirations that every lawyer should devote up to 50 hours of pro bono every year. The average nationally is now 3 hours. It's shockingly low. And given the extent of the crisis in terms of access to justice, if we have to require lawyers to provide pro bono services, we ought to do it. And certainly, getting back to the point that we have a monopoly, we need to open up the process to permit non-lawyers to assist us in meeting access to justice needs. The state of Washington has recently developed a program to certify and train non-lawyers to help in areas like family law, and frankly, we ought to be taking the lead as a profession to encourage that. The ABA's position has been to the contrary. We also ought to do everything we can to help the vast majority of people with legal problems who represent themselves. And we as a profession ought to be reaching out and supporting those who play that role. We ought to be developing websites, we ought to train people how to handle their own legal problems. And finally, since we have the 500,000 people who are retiring as senior lawyers, I've talked to a number of senior lawyers who say, I really want to figure out ways now to give back, and we have to figure out ways of involving senior lawyers in resolving the access to justice crisis. Very quickly, the two other points that I want to stress. We need to make law firms more responsive to client and public interest needs and to the development of their own lawyers. There is a culture in law firms, and maybe you would share with me my view of what that culture is, which suggests that a law firm's self-interest is more important than that of serving clients effectively. And we need to change that culture to go back to what the roots of the profession were, which is being a helping profession as opposed to one focused on self-interest. That's going to be a difficult culture to change. And I think in many ways, those of you who are going to go to big law firms can play a role in doing that by the process of when you interview to go into a big firm, you ought to try to find out what that culture is like. And you ought to indicate that if you're going to go to work for a firm knowing what has happened within the profession recently, you're going to pick one that has a better culture. Secondly, we law firms have to invest money in figuring out more cost-effective ways to serve their clients in the public interest. There is virtually no research that is going on within the profession today. Again, I applaud Harvard's for focusing some of its attention on research. And that needs to be done. And finally, something has to be done about the attitude that law firms have about their own lawyers. They consider their own lawyers, unfortunately, as cogs in a wheel. And that's not only on young associates, it's on partners, everybody but the rainmakers. And in effect, the opportunities to become partners today just declines all the time. And something has to be done to reestablish within law firms a commitment to basically support the professional development of the lawyers they have. The final comment I would make goes to what law schools themselves need to do. The profession is just not focused on what it needs to be doing going forward. Law schools, in my view, need to serve as laboratories for reform. Most academics, and I'm not being critical of this, focus their attention on law reform and doctrine, but not on the need to reform the profession. Unlike medical schools or virtually any other professional school, law schools are missing in action in terms of research and development, experimentation, again, testing new approaches for serving clients in the public interest, and that has to change. There's a schism between law schools and the profession. And again, I applaud the program here, the program on the legal profession, and your dean, who is very committed and is actively involved with the Legal Services Corporation. I finish with a comment or a quote from Justice Harlan Stone. And this came in 1934, 80 years ago. Here's what he said, and it's still so pertinent today. Steadily, the best skill and capacity of the legal profession has been drawn into service of business and finance, rather than the intangible and durable satisfactions which are to be found in a professional service more consciously directed toward the advancement of the public interest. What Justice Stone said 80 years ago remains very true today. So it's time for us to change. I wrote the book with the goal that hopefully there would be growing support for the notion that we cannot keep things the way they are. And with that, I'm happy to take any questions, get comments, and the floor is open. Yes?
So regarding the access to justice problem, when you have law school costs, not just here, but even at almost anywhere, you're going to be going into about $250,000 a day. The hourly rate you'd have to charge for the poorest sector of the population to be able to afford legal service wouldn't be enough to pay for Westlaw. There's only so far that you can go.
Well, and certainly you don't have to convince me that law school debt is a fundamental problem, but you also have to look at reality. Again, there's your opportunities graduating from Harvard Law School clearly are going to be better than the opportunities of people, including those who graduate from Maryland, where I'm now teaching. But the reality is, if you take a look at it, other than those who go to work for big law firms, and that population is going down, because you take a look at the number of summer associates that big law firms are bringing in, it is declining. So the opportunities at the top end are diminishing. And then the question is, if you set that aside, what is the average salary that a graduating lawyer makes? And the statistics I have, $50,000 or $60,000 a year. So you have this massive group, 35,000, 40,000 graduates every year going out into the field with a declining opportunity to make a lot of money. I think we can set the system up in a way that those who want to work in the public interest are going to have better opportunities to deal with their law school debt, because that's where there are going to be fellowships, that's where there are going to be loan reduction or loan repayment programs, and that's clearly what we have to encourage. But again, I don't deny your concern. And it's not just in law. You take a look at other professions. Now, medicine's a little bit different because physicians still make more money, even in the market today. But people who are graduating as engineers and architects and dentistry, they have serious loans too. And we just have to kind of adjust the system, one, to make people recognize that we're not going to get to deal with the 80% unless we make more incentives than exist today. So I think, as I say, the marketplace is going to dictate that you're going to have to look for alternatives even with those big loans.
Other questions?
Yes?
Do you believe that law school in general has become more of a factory that produces litigants or attorneys rather than something more noble? From your study, you think that there's a saturation of attorneys out there?
Well, the comparison of a law firm to a factory, although people would not have thought about that comparison before, unfortunately is getting to be more and more apt. If you take a look at the way a law firm is structured today, as opposed to the past, when I broke into the field, the notion is when you go into a law firm, the law firm brings you along, and the idea is you're going to stay there, and there's going to be a loyalty that's going to develop, and if you do good work, you will become a partner in 5, 6, 7 years. So that was the way it used to be. Right now, the factory analogy is good because out of every 10 associates that go into a big law firm, the chances are that maybe 1 or 2 at most are going to become partners. And with the idea then that law firms are now simply using young lawyers or partners to get work done in a profitable way before they move on. That's why they're considered to be fungible. And when you stop and think about, again, the notion that we are a helping profession, and we are kind of being nurtured, and we are doing things that we really care about, that process is breaking down. Now, there are some encouraging developments. Middle-sized law firms for a long time were in trouble. Solo practitioners were in trouble because of the big law firm model. But now, because clients are refusing to pay some of the big rates that firms charge, they are encouraging lawyers in big firms, and I have a number of colleagues who did this, to go to smaller firms where their rate could be lower. So it's another example of what is shifting within the profession. So just getting back to your point, we've got to get away from the factory analogy because we're frankly too close to it right now.
Professor Krantz, I'm going to play devil's advocate for a minute because you opened with a comment that the access to justice issue is as big a crisis as the access to healthcare, which to some extent suggests to me you're making an argument that is the right to legal representation an entitlement. Is this something, are you going down a path to suggest that we can't have life, liberty, and the pursuit of happiness without having a lawyer?
No, that's not quite the point I was making. My analogy is this. If somebody is sick and needs to have a doctor or medical care, we have developed a system in this country to try to make sure access to medical services is available regardless of ability to pay. If you stop and think about the legal problems people have, and you know from your experience as well as I do, that someone who is facing a crisis of some kind in a country that supports the notion of, in effect, everybody should have access to justice. We have a wonderful legal system, the most advanced in the world. But in fact, one of the points I make in the book is, if you compare us to other democracies, we are at the low end of the scale in providing adequate access to justice because of the cost of getting a lawyer, and because of the fact that so few people, in effect, are able to navigate through our legal system. So the point I was making is, if we are so proud of our tradition and our jurisprudence and the nature of our legal system, and yet 8 out of 10 people do not have the opportunity to get a lawyer to help them work their way through it, there's something wrong. Now the issue is, should we require civil legal services, which is, we're just not going to be able to get there anywhere in the near term. But certainly there are some movements on the notion that, analogous to the right to counsel in a criminal case, there ought to be a right to counsel in a civil case when fundamentally you ought to have access to it. If there's a danger that you're going to lose your children, as an example, or there is some other issue relating to your ability to survive financially, maybe little by little we ought to build in some notions that there is a required opportunity to get assistance. But I think, in the absence of, in effect, compelling it, which is not going to happen anytime soon, I'm just suggesting the legal profession's got to step up. We got to figure out a way of providing help to people who are not getting it now, as opposed to what has evolved over time, and de Tocqueville saw this years ago, that our profession in this country has aligned itself with business interests and has largely ignored the rest. And we simply should not be doing that anymore.
So where does civil Gideon begin and end? Does it begin only with those who are looking for housing and people who have a risk of losing something vital to their survival? Should it extend to people who just want to start up a business but can't afford a lawyer from a downtown firm?
Well, again, as you know, the Supreme Court has taken a couple looks at civil Gideon, and the only thing that's been suggested there is that there may be some area that there may be required rights to counsel, but other than the fact that some states have built in some statutory requirements of counsel, we're not anywhere near a civil Gideon. And all I'm suggesting is, with that as a reality, we got to figure out a way as a profession, as a helping profession, to provide services that may not be constitutionally required, but are desperately needed.
I mean, I think you focused on this access issue, bringing or incentivizing lawyers to, in a sense, move into these areas which to support people who need legal services. You mentioned this monopoly idea, which is in a sense looking at it from the other angle, providing people who are not quote unquote lawyers and allowing them to enter from a bottom perspective, if you will. Can you talk a little bit more about what that means in terms of solving the access, or at least?
Yeah, I think a good analogy might be the medical profession.
Nurse practitioners.
Yeah, I mean, you have this whole structure. There are a certain number of physicians, but you have helpers, in effect, who have certain kinds of skills, whether it's a nurse or whether... We have very little of that in our profession. We do have paralegals, but the paralegal population is really declining in this country. We have things called like contract lawyers who are lower status lawyers, but we have not figured out a way to use a variety of people that could be enormously helpful. Every legal problem is not sophisticated. There are a lot of issues. An example will be people trying to get Social Security benefits, might be an illustration, where you do not have to go to law school for 3 years to be able to provide assistance. We ought to make a more careful look at the different levels of legal problems and how, because of the crisis, because of the lack of lawyers available, we can train people to come in and help us address those problems. And in Washington State, the example I gave before, where you have all these family law issues, and a lot of people come into family court without a lawyer, what Washington State has decided is it is feasible to certify and train people to help those in family court kind of sift through the necessary documents they have to produce, would be one example. To help people fill out forms, because courts are now increasingly trying to help people help themselves. So you can come up with a variety of ways to kind of tier this. And let me give you an example at another end. Let's say there are business people who have virtually no money, but they want to start a new business. And it's not all that complicated to create corporations, but there are issues of how you can do it effectively. You have all these people who are graduating from Goldman Sachs or retired from Goldman Sachs and a lot of the big businesses. There's no reason why we could not factor in people with skills in business development, as an example, to work as partners with us to be of assistance. So the one issue that has come up is how can I be talking about opening up the door for non-lawyers, in effect, to compete with us at a time when there are no jobs for lawyers. The truth of the matter is, most of the things that I'm talking about are not going to be things that people who are graduating from the law school are going to do. And on that grounds, I mean, we can begin to think about ways that if we start to pair ourselves with non-lawyers to provide services not being provided, to do it in a cost-effective way, to take advantage of new technology, the fact is we're going to be refining or redeveloping the legal profession, because just as Walmart has found out that there's this huge population out there that's not going to Lord & Taylor, and it's possible to make money charging lower rates, the legal profession can do that as well. Yeah?
So, two questions. One is a follow-up on the last one. And it's just a clarification. is it your view that, I don't know what we'd call it, something more than paralegals but less than lawyers, should operate independently of lawyers the way that a nurse practitioner might, or that they would operate under the auspices of a fully licensed lawyer? And then my other question is more sort of fundamentally, is our law just too complex? Should we, your premise has been, we need lawyers to help people through the court system and the legal system, but the alternative is that we should just reduce the substantive and procedural complexity of the legal system itself.
Yeah. Well, taking your second point first, there's no doubt that that's the case, and I certainly talk about that in the book. Our legal system is far too complicated. I will give this credit to courts, though. There is a movement within courts around the country to try to simplify the process, because judges see on a day in, day out basis people who are appearing pro se, and they're trying to help. There is no doubt that we can make our legal system simpler. And frankly, I think the profession over time made it more complicated to justify the rates we were charging and the amount of billing we did. Now, with respect to your first question about paralegals, there are some instances where paralegals, if you're talking about complex litigation, going through document review, they would have to operate under very close supervision. But in the analogy to the medical profession, there are a lot of ways we could assign responsibility to people who are not lawyers but have certain types of training to do things with a good deal of independence. But as matters get more complicated, obviously lawyers are going to have to play a more direct role in supervising. Yes?
If you look at sort of three basic incentives of why people join the legal profession. The first you've talked about, which would be, I want to be part of a noble profession and do good. And your answer to that is, good, do more of that. And the second might be, I want to earn a good living for my family. I might even want the brass ring of partnership, or at least to pay off your student loans before doing something else. And your answer to that is, okay, let's do less of that. But the third incentive, particularly for students in this room, is I want an intellectually challenging, cutting-edge job. And leaving aside the public interest jobs, a lot of the pro bono work you're talking about is cutting-edge SSI cases, wills, divorces, bankruptcies. How do you answer that question for a Harvard Law graduate who wants to be doing something really at the cutting edge that's challenging for him or her every day?
Well, I guess, certainly intellectually challenging is an important concept, but I would also want to pair it with rewarding. And let me give you an illustration. For years, I was a litigator at the upper end doing white-collar criminal defense work, where there's a lot at stake and the intellectual issues are pretty daunting. But I also learned over time that as prosecutors got more power and people almost inevitably pled guilty as opposed to going to trial, my work became somewhat intellectually less challenging because you had fewer options available. But about 5 years ago, when I started to shift my emphasis away from white-collar work into pro bono work, I went through 2 days of training through something called the Children's Law Center, so that I would learn how to handle adoption cases in a court. And that's a different world altogether. There's a guardian ad litem, and there are different social workers, there are different parties there. And although that system is very different and in some ways less intellectual challenging, I can tell you that working my way through the process and at the end of the day, being able to see people with smiles on their face when they were able to handle an adoption was gratifying. And so it comes down to, as I say, a balance. We clearly all want things to be intellectually challenging. But if one of the things that drove you into coming to law school is that we are a helping profession and we got to help people solve their problems, and we have unique skills to do that, spending hours in a windowless room doing document review as compared to being able to go into family court and help somebody get an adoption. Or I can tell you the same thing, dealing with whether it's evictions or handling homeless problems. They're of a very different kind. And I'm not suggesting that people have to spend 100% of their time doing that. But I think without question, as I worked over time with young lawyers, with partners, with others, the notion that being able to devote a part of one's time without even thinking about ability to pay, simply helping somebody deal with a problem, is a very important aspect of, I think, what we should be doing. And by the way, I am not at all opposed to making money. I had 3 kids I had put through college. There was a point in time in my career where I was making a lot of money. But there was also a point of time where I said to myself, am I happy? And I changed the nature of what I did. I first went down, it was 50% being a white-collar criminal defense partner to 50% doing pro bono. Then it was 90% of my time to running this global pro bono program. And if you ask me today what I remember most about my career, I have to tell you, a lot of it is wrapped around the fact that I was involved in things that I really cared about. So it's just a matter of balancing all of it, I think.
Professor Krantz, thank you. This is a great talk, and you'll have an opportunity if you want to purchase the book and talk to Professor Krantz about it. You have a few more minutes before the next class, so we'd like to thank you on behalf of the program and the legal profession for sharing your thoughts and ideas about our future collectively, and we're all thinking about these tough issues.
Well, thank you for inviting me.